But I think I'd like to give the context first. It must be borne in mind that the 20th respondent was not heard before the High Court. And the basis of the Court of Appeal decision was that once the Attorney General was disqualified, so to speak, from representing him, the court should have ensured, the High Court should have ensured he was served. Let's look at the questions now. And the reason I'm giving the context is that I stick to my lane. I have not looked at what the evidence was there on anything other than surveys. But I think it's fair to say that there's no admission that the 20th respondent initiated this process. And it's important that the court does hear something about what initiation means, because I think there's been a mix-up of the terminology. If he didn't initiate it, then there was nothing to pass on. There was no button to pass on. That's the long and short of it. But it's important that what the process entails is explained, and I think the persons best suited to do that are the 18th and the 21st respondents who say they are, or they were the promoters, so to speak. So I still have time, and I ask for them to nominate whoever will speak to this, because I think the court is entitled to an answer.
My ladies, my lords, I will answer that question, although I'll ask for some time later to make a few comments on the other issues that have been raised. The involvement of the President in this matter, I was trying to look through the Gazette notices. Unfortunately, I did not get it, but they're on record that there were two Gazette notices. One Gazette notice that set up what was the BBI task force, and a second Gazette notice that set up what was the BBI steering committee. And the words that are used in those Gazette notices asked both the task force and the steering committee to look into administrative, policy, statutory, and constitutional measures that may be taken in order to secure national unity. So first and foremost, it was not a direction towards recommending purely constitutional changes, but it was an invitation to consider whether there were constitutional changes that would be necessary if one was pursuing a measure towards uniting the country. And it is from both reports then that particular recommendations were made to say that, yes, there are constitutional amendments that we can make that would help in securing national unity. And the matter ended there after the President received both reports. It is the BBI National Secretariat that has described itself as an alliance of political actors that then took up and decided to pursue those constitutional amendments by way of a popular initiative. And therefore, the real promoters of the popular initiative then are the people who styled themselves as the BBI National Secretariat, who are the 21st respondent in this matter. Thank you.
If I could go back to my Lord Justice Lenaola's question whether there's precedent in other jurisdictions. First, the starting point is that I could not, for the life of me, find anything that qualifies the President's right to do this for the reasons we gave earlier. But so therefore, I did not go out to look for this. But the Attorney General's submissions have actually given us examples, not of President, but political parties, political groupings. So when you do take time off to consider the submissions, the Attorney General has dealt with this at paragraphs 57 to 59 of their submissions. That's the first petitioner. And they've given the clearest example, which is Switzerland and what has happened, and it's nothing unusual.
Yes, my Lords, still on that issue that my learned friend Mr. Kiragu has just submitted on, just looking at an example of a popular initiative that has originated from a head of state, not a president, but a head of state. There's example of, it's a difficult word, Liechtenstein, I think is the word. The Article 64 of the Constitution provides for popular initiative, and in a referendum that was held on 14th of March 2003, actually initiated by the prince of that country, the referendum was initiated.
Which country, Mr. Karuri, which country?
Let me spell it.
Yes.
It's a difficult word to pronounce. Liechtenstein. Yeah, that country. My lord. Yeah, there was a referendum that was held on 14th of March 2003. It was initiated by the prince of that country. It had asked voters to approve an extension of the power of the prince to, among other things, nominate judges and veto legislation, and the referendum was passed. My lord, while I'm on my feet, I think I should just answer the question asked by my lord, Justice Wanjala, on whether when the popular initiative kicks in. It is correct, my lord, that I did say that the popular initiative, the provisions of Article 257 are only engaged once a million signatures have been collected. And the reason for that is obvious, that people will come up with all manner of ideas. They can try to popularize that idea, but if it does not, if a million registered voters don't sign up, don't support it and sign up, then the provisions of Article 257 are not initiated. In other words, my lord, put it plainly, because I know my lord has been a lecturer, so let me put this as plainly as I can. If you do not get the million signature, you have not popularized your idea. It is not popular. It only becomes popular when you have collected the signatures of a million registered voters. I hope my lord have answered the question. Thank you very much.
You raised a very important question on why we say the Constitution has a basic structure, but the basic structure doctrine does not apply. My humble submission, sir, is that every Constitution has a basic structure which form the foundational parts of that Constitution, and where that basic structure is not specified in the Constitution, then it is the role of court in a judicial review to find out where it is. Within the context of our Constitution, historically in the making of Constitution, this is a matter which was addressed by the CKRC Commission, and at paragraph 746, it was recommended that a number of key constitutional issues should be entrenched in the Constitution, and they could be amended only by a referendum. So it did two things. One, it identified those key foundational parts of the Constitution and included them as thematic matters under Article 255(1), and further prescribed how those provisions can be amended. Now, there was the question which was raised by my Lord Justice Ndungu on whether what is the basis of the 4 sequential steps which were included in a decision by the High Court and the Court of Appeal. The 4 sequential steps were the original basis upon which the Constitution was amended. It is neither included in any legislation or constitution under the current framework, but it arises from an interesting constitutional theory which Professor Albert talks of in his constitutional amendment and dismemberment, and this is what he says, that the theory of constitutional dismemberment suggests a default procedure to legitimate dismemberment Here, when the Constitution is silent on the distinction between amendment and dismemberment, the deep constitutional transformation that dismemberment entails can be legitimated, with a few exceptions, only by at least the same similar configuration of constitutional making bodies that made the commitment that dismemberment later seeks to undo. So if, sorry, my time is up.
Yes, your time is up.
No. For clarification, there cannot be time.
Okay. It's okay. Carry on.
So if it is intended to amend the basic structure and the Constitution doesn't provide a means of doing that, then you have to revert to the original basis upon which the Constitution was made. And that is what the court was trying to do. But in our case, that has been prescribed under the Constitution. My Lady Chief Justice, if you wish me to address the issue of public participation under Chapter 16, which you raised, I can also address it. But I would like to defer to your directions on whether there's time to do it. Yes. Now, on public participation under Chapter 16, you begin on the basis that Article 1 reserves the people's right to directly participate in exercising their sovereign power. And under Chapter 16, Article 266(2) has expressly provided that in constitutional amendment, there has to be publication and then public discussion. That's the only article of the Constitution which includes public discussion. But that is not without prejudice to the public participation in every step of legislation which, in popular initiative as we have here, commences with public participation before the county government discussions, then through Parliament, and thereafter voter education by IEBC under Article 88. And the whole of this process is to ensure that the public are given sufficient opportunity to debate the issue, discuss it before it is passed by their elected representative, and thereafter finally endorse it through a referendum. And that's how public participation is incorporated in the process of constitutional amendment, and hence the dual track amendment provision contained in our Constitution. Thank you.
Professor.
My Lady and members of the court, on the question put to us relating, I think it is my Lord Justice Lenaola, relating to the ripeness of the referendum question, our answer is a simple one, and we are in the very happy circumstances of relying wholly on what Tuyot J.A. Summarized it very succinctly at paragraph 251 of his judgment, and he says, these provisions, and more specifically subsection 2, places the responsibility of framing the referendum question to be determined on IEBC. In this instance, IEBC had not received the request to hold the referendum, and occasion had not arisen for it to discharge its responsibility of framing the question. Further, it had not been suggested that IEBC had already determined the manner or the formula in which it would frame the question or questions in respect of the referendum touching on the impugned bill. It cannot therefore be fair, and he proceeds, It was always our argument in the Superior Court that the High Court had acted totally without jurisdiction because it acted as the Supreme Court providing an advisory opinion. The High Court has no jurisdiction to provide an advisory opinion. And that question was not ripe, it was moot, and it was not open to the court. Finally, on the second question of my Lord Judge Ouko has asked, what is our view about the proposed change in the mandate of IEBC in the creation of these constituencies? And our position is very straightforward. Our powers are not what some of my colleagues are calling basic structure. I'm calling entrenched provisions. The powers of IEBC, its mandate is not entrenched. Its mandate can vary, can be amended, can be modified, can be by Parliament in its wisdom, by the referendum process, as forever.